Welcome to the Women in Wealth podcast, brought to you by Regina McCann-Hess, a certified financial planner with over 2 decades of experience. This show is for professional women who want guidance in working towards their retirement vision in learning, building, planning, striving for your dreams, and putting the work in now so that you can pursue your financial independence. Hello, I'm Regina McCann-Hess, president of Forge Wealth Management, and welcome to our Women in Wealth series. Today, we're going to talk about estate planning. And I know it's a kind of boring topic and nobody really wants to talk about it because nobody wants to see themselves going to the great beyond. However, it happens to the best of us. So let's try to prepare a little bit. And sometimes you can see the benefits of preparing a little bit so that if you're like me, you like a little bit of control. I'm a bit of a control freak. So the idea of somebody else making decisions for me doesn't fly. So this will hopefully help some people who have that tendency like me to want to control things. So, and hopefully help your family, of course, right? But you want people to inherit your assets and also honor both your wishes and the fruits of your labor for your whole entire life, right? So your estate plan should involve everything from your will to your powers of attorney, your healthcare directives, your trusts, and more and more and more, right? So taken together, these documents would represent your visions and your values and hopefully protect your legacy. Now, here's what happens if you don't write a will. If you don't have a will that's written and signed and notarized and all that fun stuff, guess what? You just made your state government your executor. They will decide, they'll step in and decide who inherits your assets, who takes care of your dependent children or your dependent adults, if you have a dependent adult that you care for. And they'll make a lot of other decisions that you may not have made. So if you're married, usually, now, obviously, I don't know the laws. I'm not a lawyer, and I'll also don't know things state to state, but usually you would assume that if you're married and you die without a will, everything automatically goes to your spouse. If there's no living spouse, then your estate would most likely be divided among your children, your living children. And if you have neither spouse or kids, then the state's going to look into your siblings, brothers, sisters, and or your parents. So let's face it, at the end of the day, you may not want some of those people to get your money. Getting ahead, this kind of empowers you to make those decisions yourself based on your own experience and, of course, your values and your vision. Now, I'm not saying that, you don't want to help out your family members, but they may not be the only ones that you want to help out along the way. You may want to include a nonprofit, something that's dear to your heart. You may want to include nieces and nephews, whatever it is. This is your opportunity to do that, as opposed to the government just saying, well, this is how it is because you didn't take the time to make your own will. So that being said, when estate planning is done right, it can help your money get bequeathed with the least possible taxation usually, right? It's all about how you have it set up, how you work within the guidelines of the federal estate tax law, and having your government or the government manage your estate often means more taxes because you didn't prepare properly. Essentially, you end up making Uncle Sam and the United States Treasury your de facto beneficiary. Thank you very much. They are very appreciative. But when it comes to taxes, the more details you include in your will, the better, especially if you have a lot of jewelry or non-essential valuables. Your lawyer might advise you to write just a letter along with your will that outlines your personal intentions for those objects. Now, let's talk about your will. First things first, make sure you draw up, notarize, and safely store a legal last will under the guidance of an estate planning attorney. Now, before you even get to that part, sit down at the kitchen table and write out a list of everything you have. And even if it's, just in your name or joint name, write it all out and decide, okay, well, this is all that I have, and this is who I want to share in my assets after I'm gone. And if there's an asset jointly held and you have a spouse and you want to talk it through with them, I think that's really a healthy conversation to have. Beware, you will have disagreements about that, and that is okay. You'll have joint assets that you'll have to agree on, and then you'll have single assets that you can, decide on yourself or compromise with your spouse, however you want to do it. But You want to do that before you get to the lawyer's office because you don't want to spend all that time in front of a lawyer having that conversation, and you want things to move a little bit more smoothly. And of course, not the time clock ticking and you're paying for that time sitting in front of the attorney. So that's the one piece of advice that I would give you is definitely have that conversation, have your thoughts predetermined on what you want and who you want to get your assets before you go to the attorney. So now also your financial advisor can help you with some of those conversations and some aspects of the estate planning. However, you do want to see an estate planning attorney to actually carry out these documents. And I'm not saying a general practitioner or whatever type of lawyer. There's tons and tons of different types of lawyers. You want a lawyer who specializes in estate planning, because if there's a mistake, it can't be updated after you're gone. So you want to make sure the person drafting your will knows all the current laws, knows all the information that they need to know to help you make good decisions and draft your documents properly. Because you can't go back and fix it after you're gone, right? You can fix it later on if you catch it, but that's just a different story. So you want to bear all that in mind, that your last will deals with your money and your material assets. The other thing is, a lot of times we talk in percentages. Okay, well, I have all these accounts and I'm going to give, in my case, a third to Colin, a third to Matt, a third to Bridget. But, some of those assets are hard to split up, like a house. How do you do that? Think about that. Should the house be sold? Should should one child get the house and the other two kids get a little bit more of a different asset? Also, sometimes when you're talking percentages, let's just say you have $10 million. Do you want your beneficiaries, or a single beneficiary, if they're, a 33% beneficiary, do you want them to have 3.3 million right away? Is there a better way to do that? So these are things that you want to think about, not just in percentages, but make them dollar values too, so that you can really see what these beneficiaries are going to receive from you. Okay. So the other thing we're going to talk about is your living will, which that dictates your medical treatments and what you wish to receive and not receive should you become incapacitated. And you want to make sure, all these documents stay up to date. You may have already had some elements of estate planning, a will, a power of attorney, a trust, and that's fine. If you do, you definitely want to have them reviewed, or you review them. And if they're very outdated, you want to update them. But God forbid you don't have anything in place and you get hit by a Mack truck tomorrow. Uncle Sam's making those decisions for you. And obviously on a state level, but still Uncle Sam of your state. So that's really not what most people would like to do. When we're talking about your will, you are going to want to appoint an executor. Now, that's the person who's going to take charge in dispersing your assets according to whatever the terms and conditions of your will. When you're appointing an executor, you want to follow some criteria. You really want to make sure that person, has a good head on their shoulders. You want to make up backup executors, like at least one or two successor executors in case something happens to the first one. You want to feel comfortable with that person or people that you're, assigning the executor role. You want to make sure that they understand, some elements of finance. And like I said, if they're in Chapter 11 or have some kind of bankruptcies on their part, that may not be the best choice of executor for you. So you want to know a little bit about them and how they handle their own finances as well. So again, getting back to that comfort zone, you want to see how they handle their own things. And of course, you want to make sure that they're going to be comfortable doing this for you. Do not surprise anybody with you just passed away and like, hey, surprise, you're the executor. Not a good plan. The person should know ahead of time. You should have conversations about it. They should know what your wishes are. They should know how to follow them. Very, very good conversations to have ahead of time, and also have these same conversations with your backup executors. This job is not for the faint of heart. I've done it a couple times. I've helped my husband do it a couple times. It's not fun. You don't want to pick somebody who has no clue how to handle money to be your executor, because quite frankly, it's a lot of work and you don't want it to get messed up. Your executor should be somebody you not only trust, but who is also at least somewhat knowledgeable about finances. So I think I beat that horse to death right now. So we'll leave that alone for a minute. Your executor may have legal right to make funeral decisions and take possessions of your body essentially, and get everything surrounded around your funeral essentially. That's another reason to communicate early and clearly through this person in advance, because you want to explain to them what your final wishes are. You want to put them also in writing for good measure. But while you might include this in your will or your other trust documents or whatever you have in your black box at the house, the funeral happens pretty quickly and the documents take months to go through, and they may not even be brought out for a couple weeks after the funeral. So this is why you need to have a conversation with somebody and have those, items written down, what you want to do, and somewhere where, people know to go look for them right away. Okay, so when you're thinking about things, if you have minor children, you want to include provisions for who's going to take care of them in the event that you or your partner die, and you need a caregiver for them. Often the caregiver you name in your will is not usually going to be the same person as your executor. It may not be the same person as your financial durable power of attorney. It's going to be somebody that you think would be, good for taking care of your kids. So that is something that you want to think about as well. There's a lot to unpack with caregiver provisions, but the same advice applies here. Be thoughtful. Seek legal counsel to ensure you've crossed your T's and dotted your I's more so than anything. These are your kids, right? These are your most precious assets. And as with executors, always make sure that the would-be caregivers understand and consent to their roles in advance. Nobody wants a surprise kid dropped on their doorstep. Believe me, I don't. So don't anybody do it to me. Also, those potential caregivers need to know what your values are for your kids, how you want your kids raised, what kind of education you want them to have. Like, they have to have an idea of what you are about and what is important for you with your children. So that's another reason to have that conversation. Okay, we're going to switch a little bit and we're going to talk about your living will. Now, that's your medical directive, right? It's a legal document clarifying your wishes for your end of life care. Should you become incapacitated, or if you're in some kind of serious injury, or you're in a coma, or late stage dementia, or even whatever else that comes to mind, this document spares your family, your loved ones, the anguish of making crucial choices during a time of crisis and grief. You can specify whether you want to be resuscitated, whether or not you want CPR, or if you want to be kept alive on a ventilator or a feeding tube, all sorts of things. You can literally do a checklist and say, yep, I want this, I do not want that. It lays it all out, all your wishes on your palliative care. Also, it mentions organ donation. A lot of us have that on our licenses, but it's also in that document. So it's a good idea, again, to have that conversation with the person that you are going to appoint for this, because not all people are up to making those decisions. They could have they could have a religious belief that limits them in being able to carry out your wishes. Like if you're in a vegetative state and you do not want to be kept alive in a vegetative state, they may not be able to carry that out because they would possibly feel the guilt of their religion falling upon them. So it's really, really important to have that conversation. Like, hey, I know it sounds heartless and cold, but hey, can you pull the plug? Like, really, can you pull the plug if I'm in a vegetative state and I don't want to be here if that's how I have to be here? Can you pull the plug for me? And if they say no, or if they like really struggle with that, you may want to ask someone else. So I've had conversations with people about this, and sometimes it can be, if it's not clearly stated in law, like written down in this living will document, there could potentially be a lawsuit or legal case that has to be fought in court over what your rights are to die, if you were in that situation. Not that not that we're saying you're going to die, but I'm just saying you want to have the right people in place. Now, that's not the only decision that they would be making. Obviously, if you're, in the hospital and you've had, some kind of life-threatening emergency and they're going to do everything to save you, there may be other choices that they need to make when you can't speak for yourself. So that's very, very important. It's also a good idea to keep a card size outline of those directives in your wallet. You want to store them in a safe, easily accessible place at home as well. You also may want to provide copies to your doctor's office, to any kind of healthcare agent. If you go to a particular hospital repeatedly, they a lot of times now will ask you if you have a living will, and you can, PDF that to your case, to your documents at the hospital. So that is actually another great idea to do. Finally, you want to make sure 2 or more trusted family members have a copy of that living will, including whoever you named in your durable power of attorney and healthcare providers. You want to have, obviously, they need copies of it, but also, 2 close family members, especially if you have a caregiver because you have ongoing health issues. That's something to think about. Okay, so healthcare power of attorney versus durable power of attorney. The healthcare power of attorney is basically what we just talked about, the legal document that names the person who's going to make medical decisions for you if you become incapacitated. And we, several ways to do that. This person's only there to take the medical directives for your healthcare. Now, the durable power of attorney, on the other hand, names the person responsible for taking care of the financial stuff. This document authorizes the person to pay medical bills, make investment decisions. Like, obviously, again, you have a checklist of what can they do, what can't they do. But obviously, if they're your financial power of attorney, durable power of attorney, you want to be able to give them the right to do things that you need them to do to keep paying your bills and whatever else needs to be done while you're in the hospital or wherever you are getting taken care of for your health. So that's really important. And as with the executor and the healthcare person, you'll want to talk to this person ahead of time and say, hey, if ever I need help because of an illness or dementia or incapacitation, would you step in as my financial power of attorney and take care of bills and, watch over my investments and things like that? And of course, same thing, make sure this person has an idea of what they're doing and knows a little bit about, being a good steward of your money. You want to have that conversation with them ahead of time. And again, also the person who's your backup plan. Okay. As with the financial stuff, you want to make sure that they have access to your documents. If needed, they should know where to go in your house for them. One of the biggest problems is right now, a lot of things are online, and you would need to have access or give people access with your passwords and things like that in case in case you needed to have them step in for you. But how do you give that to them ahead of time? You could also tell them, here in my house in this specific place is a list of all the websites, the accounts, and the passwords to get in, so that they could actually access everything. And they will have to provide access to the banks and financial companies with a copy of that power of attorney if they're going to take over for you making decisions. So that should also be something, when you have it done, you should automatically give it to your bank or your financial advisor so that they can have all that on file way ahead of when you would need it. So that's pretty important. So jumping back to some of our, legal documents, back to that, you want to make sure when you're doing your will and your trust and things like that, you want to make sure that your beneficiaries line up across all of your estate and financial planning documents. That includes your, like I said, your will, your investment accounts, your retirement accounts, your insurance policies, things like that. Because here's what happens. If your will says one thing and your retirement says another, your retirement accounts are governed by contract law. So it doesn't matter what's in your will. Whatever's in that beneficiary form for your retirement account, those are the people that are getting your money, or organizations if you have a profit. Those are the people getting your money. Same thing with insurance policies, life insurance policies. Same thing with a transfer and death beneficiary at your bank. If you've added beneficiaries to any of your accounts, it's going to go by contract law. And obviously your trust account is going to go by whatever's written in the trust. So if you have your will and you don't update your beneficiaries, like, so you change your beneficiaries over here on your will and you don't update your beneficiaries at your investment accounts and your retirement accounts and your life insurance policies and things like that, it's not going to go that way. It's going to go according to what you have on the beneficiary list at the financial institution. So just so you know that. So for instance, if I want my brother in my will, I want my brother Tom to get all my retirement money. But in my retirement account, I made my brother Mike as my beneficiary. Guess what? Mike's getting all my money, every single penny. Doesn't matter what I wrote in my will, because the contract law says, well, guess what? You made Mike your beneficiary, so he's getting all your money. Doesn't matter. So be very, very careful about that. Speak to your financial advisor. I would say at least once a year. I know it becomes redundant, but once a year, just look at your beneficiaries. Just make sure they're in line with what you want to do. Obviously, anytime there's a life transition update, like a birth, a death, a divorce, a separation, things like that, those are times where you really want to update your beneficiaries and make sure that, you're lining up with what's still your wishes with life changes, of course. So, of course, every time you update your will, you literally have to open up every single account one by one and make sure they match. Again, you just don't want things slipping through the cracks. And like I said, you probably want to schedule an annual state check-in with your financial advisor to make sure everything is lined up. Now, just for my own experience, it puts your financial advisor in a tough position when your will says one thing and your financial advisor goes through that with you and says, okay, well, your will says Johnny is supposed to get this, but your beneficiary says Jane. What do we should probably change that to reflect your will. And then you say, no, I still want Jane on there. It puts the financial advisor in a tough spot because we're trying to make sure that we're honoring your wishes in your will. But then you're telling us, no, I want it this way, which is absolutely, you're right. You can change your beneficiaries at any time. But it just, if anybody comes back asking questions, we kind of are a little bit on the hot seat. So that's just my little soapbox today. We'll stay away from it, though, because I know that's a little tough of a topic. The other reasons you want to update your beneficiaries through your contract law, essentially by beneficiary forms, is privacy. Anything that goes through your will that's probated is public information. Any scamster out there can go to the courthouse, and they do, to get this information and possibly scam your family members. Also, so when no beneficiaries are named, or in the fact that your beneficiaries are actually deceased, the transfer of money should then go through probate court. Again, that's public record. We want to avoid that at all costs. Revocable trusts, those are, living trusts. Revocable living trust allows you to control your money both while you live and even a little bit after you're gone. The revocable living trust allows you to change the terms and beneficiaries during your lifetime, anytime you want. But after your death, the trust becomes permanent and then becomes irrevocable. So a lot of people use them along with their wills to, just figure out where they want their money to go. So you want to make sure you frequently review the details of your trust, and as needed, update the name of your beneficiaries and the name of your trustees, because no lawyer worth their salt will write a trust without multiple backups. You will need to appoint co-trustees or successor trustees. And if none of these people is willing or able to manage it, the trust could typically be assigned also to a bank or a financial institution. There's professional trustees that can be used as well. So, listen, this is a tough topic. I know it's boring. Nobody wants to talk about it, but especially as women, we're so busy taking care of everyone else and everything else. We often push tasks having to do with our own physical, mental, or financial needs to the bottom of the to-do list. Hey, I am guilty. I do it all the time, as a matter of fact. But as you learn to start putting yourself first and taking back your rightful financial power, you're bound to reap the rewards of greater stability and hopefully extra wealth to pass along to your friends and family. You are worth it, and your final wishes should honor you, your life's work, and your personal values. So with that, I think I'm going to cut it off here. And I think our action item is to take care of you. Take the time to look at your wills, if you don't have a will, like, call me. I will recommend 3 attorneys so that you can go sit down and make this will. It's really, really important, as are your financial power of attorney and your healthcare directive. Those are used a lot more than you think. So those are really, really important things. So action item, if you don't have a will, call me. I'll recommend 3 lawyers if you don't have one for yourself. And if you do have a will, and if it's like over 10 years old, maybe, I would say 5 to 10 years. If it's over 5 to 10 years old, you want to really reconsider looking at it. And of course, obviously, any financial or life transition that has occurred in your family, a death, a divorce, a marriage, a child, grandchild, things like that, that's a good time to update as well. So thank you so much for listening to me today. Again, I'm Regina McCann Hess. I'm president of Forge Wealth Management. I am on Facebook, LinkedIn. LinkedIn, I'm at Regina McCann Hess. Facebook, Instagram, and YouTube, Forge Wealth. And I have my website is forgewealth.com. Go make it a great day. Now, I am going to read some of our compliance stuff, so just bear with me. We want to thank you for joining us in this episode of Women in Wealth. You can watch the founders video I created for you to learn more about how I can guide you towards your financial independence at www.forgewealth.com. The information in this podcast is educational and general in nature and does not take into consideration the listener's personal circumstances. Therefore, it's not intended to be a substitute for specific individualized financial, legal, or tax advice. To determine which strategy or investments may be suitable for you, consult the appropriate qualified professional prior to making a final decision. Securities offered through LPL Financial, FINRA, and SIPC. Investment advice offered through Private Advisor Group, a registered investment advisor. Private Advisor Group and Forge Wealth Management are separate entities from LPL Financial. Our show guests and their companies are not affiliated with nor endorsed by LPL Financial, Private Advisor Group, or Forge Wealth Management. Thanks so much for listening. Have a great day. Thank you for joining me for this episode of the Women in Wealth podcast. You can watch the founders video I created for you to learn more about me and how I can guide you towards your financial independence at www.forgewealth.com. The information in this podcast is educational and general in nature and does not take into consideration the listener's personal circumstances. Therefore, it is not intended to be a substitute for specific individualized financial, legal, or tax advice. To determine which strategies or investments may be suitable for you, consult the appropriate qualified professional prior to making a final decision. Securities are offered through LPL Financial, member FINRA, and SIPC. Investment advice offered through Private Advisor Group, a registered investment advisor. Private Advisor Group and Forge Wealth Management are separate entities from the LPL Financial. Our show guests and their companies are not affiliated with nor endorsed by LPL Financial, Private Advisor Group, or Forge Wealth Management.